My gosh, this is where the party is. Carly, did you ring the music? Cassidy, the piece.
Yeah.
Okay, good. Okay. So we will. So Christopher made it in. Adam made it in. Let's wait for Leilani to make it in.
Mm-hmm.
You are?
Yeah, you can see me.
I'm not seeing. Oh, there you are. You just popped up. Okay. Okay, wow. The party is here. Okay. Where we left off last time was with the important idea of the fallibility of eyewitness testimony. Okay. And especially when we're traumatized, believe it or not, our memories are actually less accurate than when we're not traumatized. But before I get into that, what questions do you all have about course content, etc., before we get going about other content today? Okay. Well, hopefully as they come up, you'll put your hand in the air like you're a true player, and then we'll talk about it. Okay. Here's a story. Angel Gonzalez served 20 years in prison. On March 10th, 2015, you can follow along in the notes if you've got them there, Angel Gonzalez was exonerated after serving over 20 years in prison for a rape he did not commit. In 1994, Gonzalez was misidentified by a rape victim as her assailant. After he was arrested, he was then misled by police into signing a false confession. Although Gonzalez maintained his innocence from the very beginning, it was not until 2013 that he was finally able to prove his innocence through DNA testing. So let's talk about the crime for a minute. On the night of July 10th, 1994, a woman was abducted by two men from her apartment building in Waukegan, Illinois. The victim had gone downstairs after her buzzer rang, and when she opened the door, two men grabbed her and forced her into a car. They drove to a backyard several blocks away where they both raped her. After the attack, the victim was understandably very traumatized. She eventually found a nearby 7-Eleven, and the police were called for assistance. Police obtained an initial description of the attackers from the victim. She described them as two Hispanic men, both in their mid-20s, medium height, medium weight, and slightly taller than her. She was 5'7", so therefore they were anywhere from 5'8" to 6 feet tall, and with dark hair. She described the car as dark-colored, late model, four-door sedan with tinted windows. Okay, now eyewitness misidentification. The police returned with the victim to her apartment building to search for evidence later that same night. The victim's boyfriend arrived and spoke with the police, who gave him a general description of the attacker's car per the victim. From approximately 50 feet away, the victim's boyfriend then saw Angel Gonzalez's car pulling out of the parking area on the other side of the building. Now, Gonzalez's car was not a late model sedan. It was a 1979 Cadillac with tinted windows. Okay, so not exactly the latest model. The victim's boyfriend told police that he didn't think that car belonged on the property. And Gonzalez, it's true, did not live in the building, but was visiting his girlfriend's sister, who happened to live in the same building as the victim. The officers were unable to catch up with the Gonzalez, so they tried approaching his vehicle on foot as he was leaving, and so there wasn't like a mad police chase. They were just walking up as he was pulling out. So they did obtain his license number as he was driving away. After dropping his girlfriend off at home, so Gonzalez and his girlfriend were visiting girlfriend's sister. So Gonzalez drops his girlfriend off at home. Gonzalez was stopped by a police officer on the road who approached Gonzalez's car with his spotlight on, so the spotlight on the side of the car, and the officer had his gun already drawn. When Gonzalez asked the officer why he had been stopped, he was only told that his car matched the description of a vehicle that was used in a crime that night. You and I already know that his car did not match the description. Gonzalez was handcuffed and placed in the officer's car. Notably, Gonzalez did not match many of the details that the victim gave in her description of the attackers, which had been radioed to the officer who stopped him. So the officer knew the described characteristics from the victim of her perpetrator. And the officer who stopped him could see that there was not a good match there. Gonzalez had a notable goatee, had quite a long goatee actually, that the victim did not report, and he also had a large birthmark under his right eye. Okay, the victim also did not mention that. So the victim, again, did not mention anything about facial hair or a birthmark from either of her attackers. The victim was taken to where Gonzalez's car had been stopped in order to identify him. With the squad car directly behind and illuminating Gonzalez's car, the victim positively identified the car, even though it was not a late model sedan. An officer then took Gonzalez out of the squad car and placed him in front of the patrol car with the victim, with her sitting in the back seat. So imagine the scenario that the officer takes Gonzalez and stands him in the headlights in front of a car. The victim is sitting in the back seat of a car, right? So she's about 20 feet away. The victim then positively identifies Gonzalez as the perpetrator, and he was immediately put back in the squad car, and the victim was not actually allowed to see him up close, right? She couldn't see many of his identifying features, it turned out later in the investigation. So Gonzalez was kept in police custody throughout the night after he was arrested. He was scared and confused as to why he had been taken into custody rather, and not allowed to sleep. Gonzalez, who was a Mexican national, had only been in the United States a little over a year and spoke very little English at the time. He was never told why he had been arrested, only vaguely that he had hurt a woman. Detectives Artis Yancey and Lou Marquez were assigned to the case. By the time their interrogation began, Gonzalez had been awake for 26 hours. Whew, it's a long time to be awake. Gonzalez was read his Miranda rights in English and waived them, actually not knowing what he was being told. He was just told a bunch of gibberish in English and told sí or no. And so he went sí, like not knowing that he had just, like he was agreeing, yes, I hear you. He didn't know that he was agreeing to have his Miranda rights waived. And so Gonzalez maintained his innocence and provided an alibi that he and his girlfriend had been visiting his girlfriend's sister Myrna at the time of the crime. This alibi was never investigated by the detectives, despite the fact that they returned to the apartment building where Myrna lived to examine the crime scene. So they didn't even bother to check in with the girlfriend or with Myrna. They just ignored his alibi. Eventually, Gonzalez's interrogation switched to Spanish and was led by Detective Marquez. Gonzalez was asked to write out a statement in Spanish, of which Detective Marquez typed up an oral version in English. So there's Gonzalez. He's very carefully writing out an account of everything that happened that night. He's writing in Spanish. Then Marquez, the detective, types it all out in English. Okay? It was later revealed that the two statements were completely different. Marquez fabricated the English version and turned it into a confession. Okay? That evening, a videotaped confession was recorded, which only showed Gonzalez being read his Miranda rights and signing the statement that Detective Marquez prepared in English. And so he wrote out his statement in Spanish, was told that the typewritten page in English was just the translation of what he had written from Spanish to English, and asked to sign to prove that it was true. And that's what they recorded, him waiving his Miranda rights, right? And then him signing the so-called confession, not knowing that the English document and the document he wrote in Spanish were very different. So despite having 4 alibi witnesses testify in his defense in court, because his defense attorney went, hey, you guys need to investigate the alibis, The Gonzalez's signed confession proved to be the most compelling piece of evidence in the case. Again, we'll get to that in a minute. Nobody knew the confession was fraudulent at the time. Gonzalez was convicted of aggravated sexual assault and aggravated kidnapping and was sentenced to 40 years in prison. In 2001, Gonzalez obtained post-conviction DNA testing, which identified one male DNA profile present in the rape kit. And this profile excluded Gonzalez. It could not have been Gonzalez. Although the DNA tested did not match Gonzalez, it was not enough evidence to prove his innocence because there had been two perpetrators. So even though they only had one viable DNA sample, that could not exonerate Gonzalez because he could have been the other unknown sample, right? They could not identify. So in 2012, the Innocence Project opened Gonzalez's case in order to conduct additional DNA testing and enlisted the help of the Illinois Innocence Project as local counsel. So they acted as lawyers for Gonzalez. In 2013, the Innocence Project requested that the Lake County State's Attorney Office consent to testing. Michael Nerheim had recently taken office as the new state's attorney and agreed to the testing immediately, which is shocking because you guys know that Illinois has a huge backlog in cases. So Michael Nerheim, seeing some of the irregularities of the case, bumped Gonzalez's testing way up in line. Testing done on multiple pieces of evidence, the victim's shorts, the victim's tampon, which were removed by the attacker, and sperm from the rape kit, revealed two distinct male DNA profiles, both of which excluded Gonzalez. So in March 10th, 2015, Gonzalez's conviction was vacated. However, he was not released from prison because he had a property damage conviction on his record. The conviction was a result of him breaking a sink while he was in solitary confinement. Gonzalez had been sentenced to an additional 3 years on account of the damaged sink. The day following the vacating of his conviction, Gonzalez returned to court to fight the property damage conviction on the grounds that he had been wrongfully imprisoned in the first place and that he had pled guilty to damaging the sink without an interpreter present, which was the case. So Gonzalez's second conviction was avoided and he was finally released hours later. Woo! Here's something that's not in my notes because I'm very familiar with this case, but it's something I get to tell you guys. The woman who was the victim in all of this, not to say the state didn't victimize Gonzalez, they did, but the original rape case, she really believed that it was Gonzalez, and it brought her a lot of peace of mind that he was behind bars. And when he was exonerated, that was really traumatic for her because she came to remember Gonzalez as her rapist, even though he was fully exonerated by DNA evidence. Okay, you guys get where I'm coming from there? It's really traumatizing at times the way our memories can change in the direction of our preferences. Okay. And for her to feel security thinking that her attackers, or at least one of her attackers, was behind bars, it was really re-traumatizing for her. And she will insist to this day that Gonzalez was the one that raped her, even though he could not have been. So, any questions about eyewitness testimony in this case, about Gonzalez's case in particular, or about this issue generally? Yeah, Kristen.
Sorry, my mouse wasn't working. Were the officers or detectives involved with this case, were they ever reprimanded for basically putting that man behind bars when he wasn't supposed to be?
Yes and no. So Marquez was put on notice that he was aware it, and he got a write-up as a police officer. Okay. Now, the no part of that is he committed a federal crime.
Right.
Why didn't he go to prison, right? Marquez, right?
Mm-hmm.
Lost 20 years of his life. And so that's why I say yes and no. Like for those of you that are familiar with the case of Breonna Taylor, there's, t-shirts, say her name, etc. Why aren't the officers in prison? Well, some of the officers have been relieved of duty, right? And some of them have been formally reprimanded. But a man lost his life, right? And so therefore, why are they getting what seem to be slaps on the wrist compared to the the effective death sentence they carried out on Brianna's sorry, the death sentence they carried out on Brianna when they got in a gunfight with her boyfriend. You know what I mean? So there's yes and no. You know what I mean? The law as applied to citizens seems to be a much stricter law in some jurisdictions than is applied to officers.
That's my whole, if I may, that's my whole issue with the standard that police officers I don't believe are held to is I don't believe that they are held to, that they literally are, how do I word this? They are responsible for protecting the lives of citizens, and I feel like that should really be, they should have that responsibility that they have people's lives in their hands, and when they are not, protective of those lives in the sense that they do, like in the case of Breonna Taylor, when they irresponsibly cause the death of someone's life, that they should be held responsible in the same way that someone murders someone. They shouldn't be like, you're a police officer, it's fine, it's fine, you'll get them next time, or that type of thing. I feel like that there's, just because you have a badge, you're protected, and it really, really angers me that just because you have a badge, that they're protected in a way that somebody else who doesn't have a badge isn't.
Yeah. Yeah, and it really boils down to the relationship between the AG's office and that particular police department, right? Why
Hmm.
is it that some people are prosecuted and other people aren't? Like in some police jurisdictions, police are held to a very high standard and they are investigated for murder and manslaughter charges every time they kill somebody in self-defense, right? There's still a full investigation. And so in other jurisdictions, it's just a nudge and a wink, right? And so, like, I'm thinking in Salt Lake Police Department, how, if you're randomly drug tested and you pop positive for, let's say, marijuana or something, you're immediately fired. Like,
Mm.
they have a zero tolerance policy. If you draw your weapon in a confrontation with a suspect, then that is heavily investigated. And officers have been brought up on manslaughter charges, if not murder charges, in various jurisdictions. So it's very interesting to look at the relationship between the police department and the attorney general's office and the relationship of both or either to the public. Like the other, oh man, it's been like 3 years ago, we were doing some officer training. And one of the things I highlighted is I said, okay, many of you come to this with a warrior mentality, meaning that you're here to kick ass, take names, enforce the law, right? People are breaking law, they're bad, they need to have their heads cracked in or arrested or whatever else. I said, that will cause a lot of trouble for you and the people that you're serving, right? That really the model that we are going to teach you about is what's called a protector model. And what was really hard, like many officers just got it when we began teaching this model. Some officers, it was really caused a lot of brain cramps for them because a protector model means, like, let's say I'm driving up to a 7-Eleven right after you're in the process of robbing it. You bail out of the 7-Eleven and you see me pull up in my police car and I start chasing after you. In the protector model, I am there to protect the citizen, not only the person in the 7-Eleven who was just robbed, but also the person who did the robbing. You know what I mean? And it's a very strange way of thinking for some officers that I'm there to protect them, right? I'm going to do what I can. I'm going to chase him down first, try to tackle him. If that doesn't work, I'll try to tase him. You know what I mean? I'm not just going to whip out my gun and put 6 rounds in their back. You know what I mean? And so that protector model, it's interesting that for like most officers just get it intuitively, and that's the way they've already been practicing, and they really appreciate that language. But others, it's like, no, we're the warriors. If you rob that convenience store, then I got to kick your ass and fight and everything else. Well, no, that's not a helpful mindset when you're a police officer. You're a protector first, right? So, uh, So thank you for letting me rant about that for a minute, Kristen. I appreciate it. Okay. Adam, do you have your hand up?
I do. I just thought it interesting. When you're up for 24 hours straight, you have the equivalency of a zero point 0.1 blood alcohol content,
Yep.
which
You
I've
are.
always found really interesting.
Yep.
And I've experienced it before, and you don't make good decisions when you've been up over 24 hours.
Yeah.
Just wanted to mention that.
Yeah, that's a great point. So therefore, Gonzalez was not in his right mind, so to speak, when he signed the confession, let alone the fact the confession was fraudulent, right? Marquez totally bullshitted it. Excuse my vulgarity. Kristen and then Maddie.
Sorry to put my hand up again. Mythbusters actually did a segment on this of they did like a driving track. So first they had like three drivers drive around a track I think like 50 times just normal, and then they had the people stay up for 24 hours, and then I think it was 48 hours, and then tested how well they drove. And the severity of like how worse they drove after 24 hours versus and then like 48 hours, it was bad. So like the amount of like how worse your mental deficiency gets just after 24 hours is really, really bad. So I suggest looking it up. It's really interesting.
Yeah, yeah, I'm very familiar with that episode. Thank you, Kristen. The other thing, though, many detectives know this, right? What alcohol does is it disinhibits us, right? It lowers our inhibition, just like fatigue lowers our inhibitions. Like when I'm really tired, I'm more hot-tempered, I'm more blunt with my feelings, I'm less, self-controlled. And so therefore they will keep suspects awake in order to disinhibit them, right? In order to put them in a position where they're going to inadvertently let incriminating information slip or full on confess, right? So the stress of fatigue is real, and it's something that officers can use in interrogation. Okay, Maddie.
Yeah, so I like how you brought up that when he was released, it was traumatizing for the victim, which I mean makes sense. But I was thinking of how the whole ordeal must have been extremely traumatizing for the man who was wrongly arrested, especially when he barely spoke English, as well as didn't sleep for 24, 26 hours, and then also was just kind of thrown in jail. I can only imagine how traumatizing that is. So for him, right, he's having a trauma response. All of a sudden, he's in PTSD, and it just is super interesting to think about how that would play a part into the whole incident and investigation. And I think that's important to note for him as well as her, right? Because obviously both people had different experiences, but both people most likely had similar responses where they were both responding with trauma responses and PTSD.
Yeah, yeah. So, as you know, Maddie, it's ASD, right? It's acute stress disorder at first,
Yeah.
within the first week, and then if the symptoms remain, then it's PTSD. One of the things, though, that you're also pointing out is that Gonzalez was exhibiting a trauma response all the way through because his like the stress never backed off, right? He was
Exactly. Yeah.
accused, and then he
Yep.
finds himself in prison. And for those of you that have spent time in prison, it's not exactly pleasant. So therefore, he was left in an acute stress position, right? No wonder he destroyed the toilet in solitary confinement. The guy was out of his head.
Yeah, exactly.
Yeah. So thank you. Great example, Maddie. Adam?
So you said at the beginning that he was a Mexican national.
Yeah.
So after he was released from prison, was he deported? Or
No.
would he not have been because he was falsely accused?
No, he could have been deported. Like if ICE had been a part of this, then he would have been deported. But nobody bothered calling them. So as far as I know, he may have been deported since or may have moved back to Mexico since. I don't know, but that was not brought up in the case file.
Do you think he was given a settlement based on the false conviction? Because I know a lot of places wind up doing settlements instead of going to court.
Well, especially when the Innocence Project found out that Marquez had full-on typed up a fraudulent confession and had to sign it. That's a huge multi-billion-dollar lawsuit. Well, not billions, but multi-million-dollar lawsuit. So Gonzalez may have sued, or the state may have given him a settlement. Usually, the person who has been wrongly convicted moves to sue, and then the state will settle. And I don't know that Gonzalez ever did that. He may have, but it's not part of the case file. Okay, great questions. Thank you, guys. I appreciate your participation. So let's kind of move from officer discretion, right? Recognizing whether or not there's a victim, et cetera. Now we're going to transition to what's called judicial discretion. So this is like unit 1.7. Okay, so we're moving to a new topic now. So judges have a lot of leeway in many court cases. What takes judge leeway away is when they're like minimum mandatory sentences. Okay, we'll talk about those in a minute. But judges have a lot of leeway about how they adjudicate a given case. So one is like granting or denying bail. Okay, so when you have been convicted of a crime and you're in jail, right? Jail and prison are two different things. And so you're in jail waiting for your trial, then you can be granted what's called bail, which is somebody pays a certain amount of money to guarantee that you will show up for your court dates, right? So that's what bail money is let's say Linda commits another murder, but she's my bro, and so I put a lot of money forward so that she can be free on the streets until her trial, right? So out on bail. Many of you are familiar with that term. Some of you may know what bail's like because you've had bail paid for you or you've paid bail for someone else. However, the first step is a judge deciding whether or not bail is even granted. Just because you've committed a crime doesn't mean that bail will be granted. And if it is, how much that bail will be. So there have been famous cases, for example, of celebrities like committing sexual assault and the judge granting bail, and the bail is for a ridiculously low amount, like a few $1,000s, right? In other cases, the judge may grant bail, but it's for like $2.5 million. Okay. And then in other cases, the person is considered too dangerous to be let out of jail per the judge's opinion, and no bail is granted, which means they're left stuck in jail. So Linda, I'm sorry about outing you in terms of homicide. Is that what you want to talk to me about?
No, that's fine. It's okay. I want these people to be scared of me. I was just looking up the whole Angel Gonzalez thing, and I found that he was actually awarded $220,000 in state compensation when he was released. And then he actually filed a lawsuit that settled for $9.5 million in 2018, in case anybody wanted to know.
Okay, thank you, because that was Adam's question. I appreciate you Googling that up for us.
Yeah. But that's what I want to talk about. But
cool. Okay, we'll keep the rest of it between us. Okay, so Adam, you're right that Gonzalez was given a settlement up front, it sounds like, and then later full on sued. So that's interesting because usually when you're granted an initial settlement, they have you sign a legally binding document that says you will not sue them when they give you the settlement. So it's interesting they didn't do that with Gonzalez, that he received the initial settlement and then sued for much more later. It really makes you wonder about the competence of the Waukegan, Illinois Police Department, right?
It also is probably because they committed like fraud and framed him essentially for the crime that the police department went like, here's some money. Please don't hate us as much.
Yeah,
and please don't sue you, and then he still sued them.
Yeah.
That's kind of how it looks.
Yeah, that's a good point, bud. So when it comes to bail, will bail be granted or denied? And if it is granted, how much will the bail be for? That's all at the judge's discretion, right? So Assigning,
also
what was that, Bud?
started. Some states have stopped using bail. Like, I think New York City has stopped, and parts of California, if not the whole state, have stopped using bail because bail is more of a rich man's game.
Mhm.
Because if your family has money, they can pay the 10% fee that the bail bondsman requires to put up. Say the bail is 100,000, you have to put up 10 grand, and they'll put up the rest. But that 10 grand you put up, you can't get back to get your friend out or your family member out.
Yeah, but until
But
they go to trial, right? Once they go to trial, then you get your money back. But then if I put up 10 grand and the bail bondsman puts up 90 more grand, they also charge me interest on the part that they put up, right? Doubling down your argument that this is a rich man's game. And so it's interesting because there's a double whammy for states like California and New York, or the jurisdictions where they no longer grant bail, because their jails are already overcrowded. So they've got human rights violations in two ways, right? One is I am going to stop granting bail because it only serves the wealthy who are disproportionately white. But if I do so, now I've got other human rights violations because now we've got people stuffed in prisons or jails that were already overcrowded. So they're really
no, they're still granting it per se, but they're not charging money.
Oh, there we go.
Like it's under the judge's discretion now to grant release, and they normally ask for like somebody in the community to vouch for them.
Oh,
That they're not going to like flee.
yes, reference. Adam, do you have? If I remember correctly, your Google foo is mighty.
What?
Your ability to look things up on Google is mighty.
Yes, this is all from memory from articles.
Okay, so would you be so kind as to look up the difference between bail and bond? Out on bail versus out on bond. And while you look that up, so one of the things that judges can also do is assign counsel for indigence and accepting counsel, right? It's a very interesting idea. How many of you have a lawyer on retainer? Okay, Brooklyn does. She's fabulously wealthy, right? Yeah.
I'm glad I found it.
Okay, what's the difference between bail and bond?
So, defendants who secure the release with collateral, property, or promise to pay are bonded out, and people who secure the release with money are bailed out. So I guess like you put up collateral, like say your parents' house, and then you can get out,
Okay.
or your house,
Okay.
and then, or you actually just put up the money and then it's bailed out.
Okay, thank you. Because one of the things that always confused me is in court, I've noticed that those are used synonymously, but they mean different things, right? One is you put something forward, an object, and the other one is you put money forward. So thank you, bud. Okay, so therefore, many of us, if we were accused of a crime, we would probably rely on the state to provide a defense attorney for us, right? Now, some of you might be able to afford lawyers. They're surprisingly expensive, but therefore there are these people called public defenders, and that is assigned by the judge, okay? So limiting, reducing, and dismissing charges is also something judges can do, okay? So therefore, it is in relation to a judge where they decide what it is that you can be charged for, and they can limit the charge. Let's say you are charged with first-degree murder, they can reduce that charge to second-degree murder, right? And they can also dismiss charges altogether. So this has happened with a few of my clients recently where two of them had pretty hefty drug charges. And between the time they were initially arrested and then the year and a half later when they finally went before a judge, because there's huge delays in our justice system, as many of you know, that they had done so much good work. They'd gotten in recovery, they had, turned their lives around, et cetera, that by the time the judge met with them, he's like, well, you've done all this superhuman work to improve your life. I'm just going to dismiss the charges, right? And so in other clients' cases, when they do put forward a lot of good faith effort in terms of community restitution, et cetera, where it seems sincere and was not signed by the judge or assigned by the judge, then the judge will sometimes just dismiss the charges outright. Okay, so judges have a lot of power. And so another thing that judges can do, interestingly enough, is admitting and dismissing evidence. And so we'll get into that here in a minute, but one of the things that is disheartening for those of you who have read the history of race conflict in this particular country are the ways in which people who are Caucasian or who are accused of committing crimes against African American suspects, the ways in which certain jurisdictions, the judges would strike from evidence the evidence that would convict the white assailant, right? That it was all part of the racist dynamic going on in that particular court at that particular time, right? So they can just dismiss evidence. Now, they need to have a reason to do it. Judges may have a lot of power, but that's also where appeals come from. So let's say Cheyenne is accused of a crime of not sharing her donut with me, and I strike certain things like donuts from evidence, and then I do that arbitrarily out of spite and pettiness, and then later it turns out there's another donut sitting right there on her table to share with me, right? Thank you, Cheyenne. But that means that she can appeal that and will likely win her appeal because there was evidence that was arbitrarily struck. So it's not like judges can necessarily just do this willy-nilly at a whim, because if their rulings are consistently overturned, then that puts them in very hot water with their constituents. You guys know that you vote for the judges in your counties, right? That you can actually look at their records, and let's say there's a judge who really screws Lexi over, and she goes on camera and newspaper and websites about the way in which she was done wrong by this particular judge. She may very well be the voice that makes sure that judge doesn't get reelected, right? So judges can't necessarily do it willy-nilly. Please, Shan.
Can't judges also be not fired by the people, but can't public opinion get a judge removed also? I remember Brock Turner, a lot of people were pissed and were calling for him to get stepped down. I don't know if he ever did. But can't we, people also do that, not just re-elect them, but they can remove them?
Yeah, there are standards that judges have to follow ethically, and if they violate those standards, then they can be removed from the bench. And judges are also lawyers, right? So if their behavior is egregiously unethical, they can even be what's called disbarred, which means their credentials as a lawyer can be revoked.
Okay.
And so there are voluntary step downs and forcible step downs, and the forcible step downs usually involve official action by the state, right? Unofficial is when public opinion turns against you to the point where you can't effectively do your job as a judge, then you might have to voluntarily step down. So great question. Thank you, Cheyenne. So the other thing that a lot of people don't know is that a judge can accept or reject a jury's verdict. So some of you who have done jury duty, it might surprise you to learn that you might spend these weeks or months even serving on a jury only to learn that the judge can just ignore what you say, right? You can reject the jury's verdict. Now, the judge has to give a reason why she did that, right? And it has to be a good reason, again, or it avails to appeal, right? Prosecution could appeal, the defense could appeal, etc. And so there's usually a good reason, not always, but there's usually a good reason why there's a verdict accepted or rejected. Like if a jury, for example, finds the defendant guilty, even though the vast majority of evidence demonstrates that she is innocent, then a judge can overrule that, right? Unfortunately, the opposite is also the case, where a judge can convict somebody even, well, all they can do is accept or reject, right? They can't actually convict, but they can accept or reject the jury's recommendation. They can't actually apply their own conviction in the face of the jury, but that still gives judges a lot of power. The idea, though, is it's supposed to protect a given citizen, right, from the abuses of the jury, that the judge can accept or reject the jury's recommendation based on what's going on, right? So if there's a very particularly unpopular defendant and the jury is already biased against them, then the judge may reject that recommendation to convict, okay? So also, judges have some leeway when it comes to sentencing. Now, again, they're what are called minimum mandatory guidelines. Like, one minimum mandatory is if you're caught with a certain quantity, a small quantity of drugs, and a firearm at the same time, like you've got a certain quantity of drugs on your person, say a couple of joints, and you've got a gun on you, that now the minimum mandatory crime for that is 10 years. Okay? And there's nothing a judge can do about that. They can't give you a sentence less than 10 years. The minimum sentence is 10 years. Okay? There are a lot of minimum mandatory sentencing guidelines now. Our culture, especially around drugs, right? Our war on drugs, that's a lot of minimum mandatories. Like one of my clients in prison, when I met him, he was 19. He was arrested at 18, shortly after his 18th birthday. And he was almost 20 when I met him, and he'd just gotten into prison. He had 3-gallon bags of prime red bud, right? Oh no, sorry. 2-gallon bags of prime red bud and a gallon bag of Maui Wowie. So 3 flavors of cannabis. And sorry, 2 flavors of cannabis in 3 bags. And he was given 25 years hard time. Okay. Another one of my clients was a serial rapist. He'd raped half a dozen women in the Gary, Indiana area, and he was doing 10 years. Okay. Because there's minimum mandatory sentencing around drugs, there's not minimum mandatory sentencing around sexual assault. We live in a really screwed up world, just saying. So therefore, there's a lot of push to change the drug laws in our society because the minimum mandatory sentencing is doing a lot of harm. Okay, so apart from minimum mandatory sentencing, judges have a lot of leeway in terms of what they sentence people for. So once you're convicted, then a sentence is laid down. Is it a fine? Is it probation? Is it community service? Is it jail time? Is it prison time? Jail time is usually less than 2 years. Prison time is usually 2 years or more, okay? If you're curious the difference between prisons and jails. Prisons also usually have, not necessarily better, they have a more systematized infrastructure for things like education and rehabilitation and job development, job training, et cetera, whereas jails don't. So oftentimes, when I'm working with men and women who have been incarcerated several times, they often prefer prison over jail, okay? Because jail, there's not a lot of things to do and not a lot of opportunities for growth. I think I see Adam's hand up.
What about a suspended sentence? For a mandatory minimum, could they suspend that sentence?
Yeah, within certain restrictions. So I'm thinking of a case of a man who was, my computer's making noise. He was a caretaker for 2 parents, both of whom were chronically and terminally ill. And he was smoking marijuana, and he would carry a gun on his person because he often had a lot of cash on him because his parents didn't believe in things like checking accounts or savings accounts. So they did everything on a cash basis. And so he was convicted of the 10-year minimum mandatory, but the sentence was suspended until after his parents died. And so this guy loses his parents, both his parents over the course of 2 years, and then goes to prison for 10 years. So it was temporarily suspended. Now, I don't know of any cases off the top of my head of indefinite suspension.
Well, I thought some suspended sentences would be if you get 10 years, but it's suspended, and if you don't commit a crime, if you keep your record squeaky clean by the time that you would have been out, you just don't go to jail.
Ah, yes, that's a good point. That there are, in certain cases, a judge may offer that discretion, which is, I'm going to go out on a limb. You've insisted that you're rehabilitated now and that you're a good person. So I'm going to hold this suspension in reserve. And if you screw up once, you're not only going to do the time for your next screw up, you'll also do time for the sentence that I've suspended. You're right, that in some jurisdictions they can do that. Okay, I'm loving this. Brooklyn's cooking. Cheyenne's had break. I need to eat. I am hungry. Brooklyn, would you share? Awesome, thank you. I appreciate it. Okay, and then Cheyenne, as we know, has those other donuts there for me too. So it's going to be a good morning. Okay. So here is a transcript from a case. You guys ready for this? So judge. So court setting, right? Judge asks, the witness. Sorry, the officer. Judge, Mr. G cooperated with you in every way, correct? Officer says, oh, he was very cooperative. Judge, and you had your gun out during that entire period. The officer, that is correct, sir. Judge, where was the gun pointed, sir? At his stomach, midsection, or head? Officer, actually, it was nestled right in the back of his neck. Judge, did you say anything to Mr. G, by the way, sir, concerning what would happen if he moved or tried to get away? Officer, yeah, I said I'd blow his head off. Judge, it was during this time when Mr. G had that 38 special cradled in the back of his neck, 38 special is a gun, that you told him his rights under Miranda. Is that correct? Officer, yes, sir. Judge's ruling. I think it is a very unusual circumstance to have a gun pointed at the back of someone's head during the course of a statement. No question that it raises substantial questions as to whether or not the statement was voluntary. However, I think the officer acted reasonably under the circumstances. The defendant could have just said, I have nothing to say, and it would have been the end of it. So I would not find the statement involuntary, even though the gun was pointed at the back of the defendant's head. Okay, for a minute there, I thought Cassie was going, whoa, but it turns out she was just yawning. For me, this is a whoa. So the judge rules that the officer has his gun right at the back of the suspect's head, right? Waves, like treats him this way, basically threatening his life. And the judge goes, yeah, everything he said after that, he was totally voluntary, right? So therefore the confession, everything else was totally voluntary, even though the suspect had a gun nestled in the back of his head by the officer, okay? My goodness gracious. So I share that example just to show you how much discretion judges have. I don't know how you would rule. I'm happy to bias you and say that if I heard from an officer that a confession was extracted from a suspect with the gun nestled at the base of the suspect's skull, I would throw the confession out, right? Because I don't know if the confession was real or fake. Something that some of you may know is that torturing people, whether it be emotionally, like threatening their life, putting a gun to their head, or physically, doesn't actually get you accurate information.
What?
Yep. Instead, what they will do is they will tell you anything that they think will get the emotional or physical abuse to end. Okay? So like Lexi and I, we work black ops for the CIA on the weekends, right? It's a way to make extra cash. And one of the things that many of you know is the most sensitive part of the human body when it comes to torturing people isn't the mouth, isn't the genitals. That's a Hollywood invention. It's actually the back of the knees, right? If you want to really create a lot of excruciating pain very quickly, you take a large drill bit and you start drilling into the back of the knee joint, right? I mean, it tops out the pain scale like nothing else. But here's the thing, as we do that, Lexi and I learned the hard way that people then immediately start screaming out whatever information they think we want in order to get the pain to stop. But that has nothing to do with the accuracy of the information that they share. Likewise, when you put a gun to somebody's head and demand that they tell you that you committed a crime, you're going to tell them even if you didn't, because you'd sure as hell not like to get shot, right? And so therefore the confession is invalid. And so I would just strike that. If I were the judge, I'd just strike that from evidence, that confession isn't valid because you literally extracted the confession at gunpoint. Okay, Adam has an opinion.
It's the fruit of the poisonous tree doctrine.
Yes, thank you.
I took a criminology class when I first came to EVU. It was really interesting.
Yeah, fruit of the poisonous tree doctrine, right? That a poisonous tree, like you poison the tree by torturing somebody, so therefore their confession, the fruit is invalid.
Yeah, or if you do an illegal search, anything that you find after that or because of the search gets thrown out. Like if you pull over a drug trafficker and you illegally search the car and you find a dead body in the trunk, but it was an illegal search, you can't charge them for the dead body.
That's a great example. That's a fruit of the poisonous tree. So Lexi, legit, right? From now on, you don't just torture people. Okay. No.
Psychological torture.
Actually, interesting enough, and I've got you guys over time, so I appreciate, Brooklyn and her sweetie need to have breakfast. Cheyenne needs to bring me that donut. But the most effective way to get information from people is by being their friend. So I've got some stories about that I'll share later in the semester. That it's interesting how much my clients have shared with me about their crimes. I didn't ask, right? They volunteered it. Okay, so we're out of time for today. I will see, let's see. Are we here on Friday? Good. No. You guys get to watch your videos on Friday. So for those posting videos, post your videos there should already be posted from last week. So review those videos and answer the questions. And I will see you all on Monday.
Hey, Matt, before you go.
Oh, Cheyenne, you had a question?
I did.
Oh, she froze. And then disappeared.
Matt, you have to tell the police if your client admits to a crime because you're not a lawyer, right?
Okay, would you ask that question again?
You have to report any crimes that your clients tell you about because you are not their lawyer and you are not bound by that confidentiality, right?
No, I am bound by confidentiality. So therefore, let's say Leilani is my client and she was convicted of 3 homicides, and in therapy she tells me about 3 more that the officers didn't know about. I get to exercise my therapeutic discretion as to whether or not to share that. However, there is no mandate that I share that information. I'm not legally obligated to as a therapist. And so what I would do ethically, according to the practice of clinical forensics, is I would work with Leilani to come clear on her own about those crimes, but I wouldn't out her. Now, if in prison she is telling me, I've killed these 3 people, I've arranged for 3 hits, and I'm going to arrange 3 more this week, then I'm obligated to share, right? Because that falls under duty to protect.
So it's only if they're gonna hurt themselves or others do you have a duty to tell, but not of past crimes.
Yep. And so my clients historically who have told me about other crimes that they have committed, insofar as it was a violent crime, then I've worked with them to call their lawyer and to get all of that straightened away, because there are loved ones, for example, who don't know why their son Johnny was killed or where their daughter disappeared to 2 years ago, when my client knows where her body is buried. You know what I mean? That it's important for those families to get closure. And so I work with my clients to that end. And the several that I've worked with that have done that have confessed and they usually struck deals. Like they're usually serving, anywhere from 40 to 8 to a life sentence anyway. So therefore, they will usually just say, hey, don't add more time and I'll confess to these other crimes, right? And that's usually the way it plays out.
Cool.
Okay, I don't know if this fellow is Mr. Armstrong, but I'll be there for breakfast in a minute, bud.
Have a good one.
Yep, see y'all later. Great questions. Thank you, guys.